Hello everyone, today we're going to have a look on the case of Public Prosecutor vs Aziz bin Shah. The accused, Aziz bin Shah, was charged with the murder of a girl aged 3 years old named Zarina binti Abdullah under Section 302 of the Penal Code. The evidence showed that the accused had come back from buying some food and subsequently started beating the child because she was crying and did not want to eat when the accused tried to feed her. The accused slapped the child and covered her mouth using a pillow and punched the child on the chest many times. It was started when the deceased was taken by permission from the grandmother, which is SP4, to be brought to live with the mother, SP2, in Chowkit. It was later when she met the accused and they went to Terengganu to meet the accused family before going back to Kuala Lumpur together with the accused's two younger brothers, which are SP5 and SP6. It all happened on the night of 1st May 2001, where the deceased mother, which is SP2, left for her work, leaving her child with the accused and his two younger brothers. She testified that the child was fine and sleeping when she left for work. SP5 testified that on the night of the incident, he was sleeping when he heard the child crying. He then woke up and saw the accused beating the child. His testimony went on to say that the accused had first slapped the child, then the accused covered the child's mouth using a pillow, and that the accused also punched the child on the chest many times. SP6 in general gave the same version of evidence as what SP5 had testified. On the night of the incidents, he was in the same room as the accused, SP6, and the child. The accused had just returned from buying some food for them. He tried to feed the child, but this was refused by the child. Then he started beating the child by slapping her. When asked how many times that accused slapped the child, SP6 answered, "Many times." SP6 further stated that after the slapping, the accused started punching the child on her chest and stomach. Then the accused had used a pillow to cover the child's face before the deceased stopped crying. The accused then later took the child to Hospital Kuala Lumpur, also known as HKL. SP8, who was the person in charge of the hotel that night, testified that she saw the accused going in and out of the room 2028, in which later came out holding that child in his arm and asked her to open the door because the accused wanted to send the child to the hospital. The accused dropped by at the place where SP2, the mother of deceased, was walking before going to the hospital. However, the child was declared dead as they showed no signs of breathing, blood pressure, and pulse, even though she was given respiratory treatment, oxygen, and cardiopulmonary resuscitation (CPR). The pathologist, which is SP7, who performed a postmortem on the body of deceased, gave his opinion on the cause of her death. According to the postmortem report prepared by SP7, the cause of death was identified as abdominal injury due to blunt trauma. SP7 in his testimony had said that the injury to deceased's liver was most probably caused by a heavy blow to the abdomen part. A weapon which is hard and blunt in nature could have been used to cause this.
So now moving on to the issues and applications of the case. The very first issue is that whether the blows were intentional and injuries sufficient in ordinary course of nature to cause death. The accused, however, did not deny that he had hit the deceased with his hand. What appeared in evidence was that he had a different version as to the degree and the nature of the blows inflicted. However, the brunt of the prosecution case was that the facts showed that from the way in which the injuries were inflicted, as adduced by the evidence of SP5 and SP6, the accused, when beating the deceased, had used all his strength. We do bear in mind that at the time of her death, the deceased was only 3 years old, while the accused, being an adult male, was aged 22 years old. The prosecution further relied on the evidence of SP6 that several blows were inflicted on the deceased and consistent with the testimony of the SP7 injury, which had contributed to the death of the deceased. So the next issue of the case is that whether the mens rea was present as the most important ingredient of murder. The counsel was urging upon the court to reduce the charge from Section 300 to Section 299 of the Penal Code. It was said that the main ingredient that was lacking according to the defense was the mens rea itself. It was obvious that the most important ingredient of murder is mens rea. However, that at that stage it was not certainly indicated under which limb of Section 299 the charge should be amended to. Section 8 of the Evidence Act 1950 was referred, as well as Public Prosecutor V. Halim bin Din.
Before we go further, let's have a look on what other laws implies for this case. Section 299 of Penal Code. Whoever causes death by doing an act with the intention of causing death, or with the intention of causing such bodily injury as is likely to cause death, or with the knowledge that he is likely by such act to cause death, commits the offense of culpable homicide. Section 300, paragraph A. If the act by which the death is caused is done with the intention of causing death. Paragraph B. If it is done with the intention of causing such bodily injury as the offender knows to be likely to cause the death of the person to whom the harm is caused. Paragraph C. If it is done with the purpose of causing bodily damage to any person, and the bodily damage put forward to be give pain is enough in the normal directions of nature to cause death. Paragraph D. If the person doing the act knows that it is so about to take place dangerous that it must in all chance cause death, or such bodily damage as is likely to cause death, and thus feels it is right to do such act without any let-off for being the cause of the danger of causing death or such damage as said before. Section 302 of Penal Code. Whoever commits murder shall be punished with death.
And now I'm going to talk about the judgment of the case Public Prosecutor against Aziz bin Shah. The question that was raised by the counsel is that the probability of the death and the presence of mens rea. It is found that the blows inflicted by the accused were intentional, and the probability of death was high, for the testimony of SP7 was that the injury was sufficient in the ordinary course of nature to cause death. At the end of the case for the defense, it was found that the prosecution had established its case beyond reasonable doubt in the context of the limb C of Section 300 of the Penal Code. It was therefore held that the accused was guilty as charged and the mandatory death sentence imposed. The accused convicted and sentenced to death.